Uh, Good evening, all, and thank you for joining us today. I am extremely delighted to welcome you all once again for an important RTI session. Before we start, for those of you who are new, Moneylife Foundation is a 12-year-old non-profit organization primarily engaged in spreading financial literacy and advocacy for savers. We also make efforts to spread consumer awareness on various issues that are of interest to our members. Over the years, we have had many sessions and workshops on the RTI Act and have also actively promoted the effective use through our sessions and through our RTI Advice app. And in today's session, we are going to have Mr. Shailesh Gandhi explain to us how the Act has been misused by applicants and how even information commissioners sometimes misinterpret it. Many of you today already know Mr. Gandhi, but allow me to formally introduce him. Mr. Gandhi is a center, uh, former Central Information Commissioner and is also an RTI activist the first RTI activist who became the Information Commissioner. He has served in the commission for almost 3 years and 9 months, during which he disposed of nearly 20,000 cases and also completely digitized his office. After serving in the commission, Mr. Gandhi continues to remain active in all matters related to RTI and dedicates his time to helping citizens learn more about the Act. He is also present as an expert on our RTI Advice app, where he takes the time to answer your queries on specific RTI applications. A link to download the RTI Advice app will be shared in the chat. Before I hand it over to Mr. Gandhi, allow me to share a few ground rules for this session. We have kept all of you on mute for the benefit of all involved so that you can only unmute yourself during the Q&A session. For optimal viewing, we suggest that you keep the webinar on speaker view. The meeting is being recorded and the recording will be uploaded to our YouTube channel, Moneylife TV. During the Q&A, please use the raise hands button available on Zoom if you wish to ask any questions. Also, a small request, keep your questions limited to under 90 seconds. Please feel free to share your comments, questions and observations in the chat, but please do it in the public forum for everyone. Please do not send us a private message as we will not be able to monitor or reply to the same while the session is live. Please also note that your cameras may be on by default and you could be broadcasting your background and homes for everyone to see. You may want to keep your cameras off to maintain your privacy, so you may do that now. And without taking too much of your time, I may now request Mr. Gandhi to please take over. Sir, over to you.
Thank you, Akshay. Thank you for that introduction. And I want to thank Moneylife for persisting with right to information as a subject which they are promoting and pushing and trying to arrange such webinars. Friends, I've been an RTI activist since quite some time now. And generally, I oppose people who say that RTI is misused and that there is blackmail. But today, let's also recognize that there is certain misuses which should be stopped and which can easily be handled. So I'm going to first talk about misuse by users and subsequently, but compared to that, on a relative scale, the misuse by the authorities and by public information officers, commissioners and others is enormous. There's just no comparison. But we are recognizing that there is some misuse by active users. The major misuse of distorting the law is with the officials concerned. So I'm just going to share my presentation. Just give me 10 seconds. Is the presentation visible?
Yes, sir.
So we'll talk of misuse of RTI and we'll start with ourselves first, RTI users. Alleged misuse by applicants. Typically, PIOs and others tend to call anybody who uses RTI multiple times as a misuser, which is not completely correct. So let me share with you what I have learned through my experience. Multiple RTI applications are filed by the following categories of people. One, citizens who want to improve the society and suspect some wrongdoing. That's a very legitimate use of RTI, and such people also tend to file a number of RTI applications because they're trying to unearth some wrongdoing. And a lot of success has been obtained by such persons. Citizens who want to improve the society, citizens who want some information for research or knowledge. That's also a very legitimate category, and number of RT applications they file can be enormous. Though to the first two categories, I would submit with one PIO or with one department, do not file more than few applications, spread it out over different things over different periods so that the load does not become too heavy for a public information officer. Then there is a category who feels some injustice has been done to them. This is a difficult one because they feel injustice has been done and they want to correct the injustice, and sometimes the information available will not resolve their injustice. The fourth category is those who want to use it for blackmail. Now, though I do not approve of blackmailing by anybody at all, I sometimes think about it from a slightly philosophical standpoint. In RTI, what blackmail can happen? If the record shows something wrong is occurring, then some people use it to blackmail people. At times, this is also raised as a bogey when actually nothing like this happens by the government officers to increase their kitty. And sometimes I wonder, there is somebody who's doing some wrongdoing. He's like a thief. And somebody pickpockets him and takes some money out as his share. Society is not concerned about the basic wrongdoer, but is more concerned about somebody who pickpockets from a wrongdoer. I think we need to think a little while. Actually, wrongdoing should be stopped by the authorities and by government. They don't do it, and therefore they have scope for some to blackmail. The fifth category is a difficult one, to get some work done. I have come across people and people have told me, and I have told them that that's the wrong way of using RTI. A person wants to get himself transferred and the officer does not oblige, so he files 50 or 100 RTI applications just to put pressure. This is wrong. And these kinds of misuse can be easily corrected by PIOs by one, putting all RTI applications and responses on the website with search option by applicant, PIO, department and subject. If this happens, blackmailing becomes zero. There is no possibility of blackmail. Nobody will subject to blackmail, because if things are on the website, who is going to pay for any blackmail? In case of multiple applications to get some work done, offer inspection of files. This is another useful way of doing it. If there are multiple applications, the PIO should offer and say, do an inspection of the files. And if there is nothing that they want to hide, there should be no real problem. Send letter asking for additional fees within 5 days. PIOs at times feel annoyed with somebody who files multiple RT applications, and therefore they delay the response or don't give any response at all, which is wrong. They should in fact give a response within 5 days and ask for fees to be paid if fees are leviable, because some fees leviable for the information to be provided. In such cases, this is something that should be done and would act as an impediment. Now, I want to take you through a few sections of RTI. Section 6.2, an applicant making request for information shall not be required to give any reason for requesting the information or any other personal details except those that may be necessary for contacting him. There is no requirement to prove public interest in disclosure. Some PIOs say, and this is wrong, this is wrong interpretation of the law, citizens own the government. Government is yours. As a democracy, we own the government and we do not have to give reasons for seeking information. It belongs to us. The default mode in RTI is it recognizes that this is a fundamental right of citizens and therefore no other reasons need to be given. Only exception is if an exemption applies, and you concede that an exemption applies. If there is a larger public interest in disclosure, you can argue like that. It's a very difficult proposition and therefore I would submit to all citizens. Stress on the fact that no exemption applies, and in most cases no exemption applies. Exemptions are wrongly applied, which we'll deal with a little later. I'm quoting from the RTI Act. On receipt of a request under Section 6, a PIO shall, as expeditiously as possible, in any case within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed, or reject the request for any of the reasons specified in Sections 8 and 9. These are the only two sections based on which information can be rejected. Section 9 covers copyright. So if providing information would infringe somebody's copyright, then it can be denied. Section 8 has 10 clauses, which we'll look at a little carefully. This Section 8.1 comprises of 380 words. Once you understand that, there is nothing further to be understood. And no other default mode is you own the information must be given to you. When a request has been rejected under subsection 1, PIO shall communicate to the person making the request the reasons for such rejection. Reasons must explain how the exemption under section 8.1 applies. Quite often, PIOs say this is confidential. Wrong. That is not as per the law. This is misuse of the law. Wrong understanding of the law, or wrong because of mischief, trying to deny information. Some people say matter is under process, therefore we cannot give information. Again, wrong. The Act does not specify any such exemption. I've seen very honest, straightforward bureaucrats using this reason, saying the matter is under consideration, therefore we will not give information. It is absolutely not as per the law. I've seen applications being rejected saying section 8.1a, b, c, d, whatever. They must give some reasoning as to how the section applies, not merely quote a thing, because then how does a person know what to do? The period within which an appeal against such rejection may be preferred should also be intimated. The period is 30 days from the rejection that you must file your first appeal. The particulars of the first appellate authority also have to be submitted to you. Supposing he is not responded to you at all, or he is not given the details of the first appellate authority, how do I find which appellate authority to go to? A simple technique is to file a first appeal to the first appellate authority, care of public information officer, and right below that the law requires you to give me details of the first appellate authority. Since you have not done this, I am therefore sending it to you, and you will have to forward it to the first appellate authority, and it works. You are perfectly within your means. Section 22 is another section which is very useful. Provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in the Official Secrets Act 1923 and any other law for the time being in force, or in any instrument having effect by virtue of any law other than this Act. Very clearly, this section says that the RTI Act supersedes all other laws and acts as far as giving of information is concerned. If any other law or rules specify that information should be given by one route, if it is consistent with the RTI Act, fair enough, there should be no problem in giving information under the RTI Act. If it is inconsistent, then also the law says the RTI Act will prevail. I've seen some judgments and of commissioners and others saying that if there is a method of providing information, that cannot be considered inconsistent, which is completely wrong misuse of the provision of section 22. That is the impact of actually an illegal amendment to the Act, which must not be permitted. The purpose of today's exercise is to lay stress on rejections and how to counter them. Section 23 says no court shall entertain any suit, application, or other proceeding in respect of any order under this Act, and no such order shall be called in question otherwise than by way of an appeal under this Act. In simple words, what it means is the final appellate authority is the Commission. After that, the courts have no right to hear an appeal against an order of a Commission. The final appellate authority, I repeat, is the Commission. Lots of cases are there in courts. How are they being there? And a lot of times public authorities challenge Commission's positive decisions before courts. This is done under writ jurisdiction. There is a difference between writ jurisdiction and appellate jurisdiction. And what is writ jurisdiction has been defined by Hari Vishnu Kamath versus Ahmed Sheikh by the Supreme Court. And the following proposition was laid. Certiorari, which is what writ jurisdiction is about, will be issued for correcting errors of jurisdiction. So supposing a matter cannot be heard by Information Commission, but they've heard the matter and passed an order, that'd be wrong. Supposing you have a grievance and the commission orders correction of the grievance, that would be wrong. Certiorari will also be used when the court or tribunal acts illegally in the exercise of its undoubted jurisdiction, as when it decides without giving an opportunity to the parties to be heard or violates the principles of natural justice. A hearing must be given to the public information officer before an order is made asking for information to be provided. The court issuing a writ of certiorari acts in exercise of a supervisory and not appellate jurisdiction. One consequence of this is that the court will not review findings of fact reached by the inferior court or tribunal, even if they be erroneous. In simple terms, a penalty order issued by a commissioner cannot be challenged in a writ jurisdiction. Unfortunately, people are doing it. Facts cannot be challenged in a writ jurisdiction. Unfortunately, that's happening. An error in the decision or determination itself may also be amenable to a writ of certiorari if it is manifest error apparent on the face of the proceedings. For example, when it is based on clear ignorance or disregard of the provisions of the law. In other words, it's a patent error which can be corrected by certiorari but not a mere wrong decision. Even if the court feels that a decision is wrong, it does not fall in writ jurisdiction. This is what it says. Therefore, if you got a positive decision from the commission and the public authority challenges it in court, put this across to the court and say, sir, please establish that it falls under writ jurisdiction and not under appellate jurisdiction. A lot of cases are going to courts which are not as per the law, not as per the Constitution of India, and this is being done by courts without jurisdiction. High courts do not have jurisdiction to hear a second, third appeal beyond the commission's state. Now we come to the exemptions, the hard core of what is used to reject legally. This is a legal rejection, provided the exemption is used properly. 81A, the 380 words that we are talking of, notwithstanding anything contained in this act, there shall be no obligation to give any citizen. Just a minute. Yeah, I need to change my specs. Information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific or economic interests of the state, relations with foreign state or lead to incitement of an offence. This is a very broad exemption which covers a lot of things. Quite often, PIOs say 81A applies, therefore I will not give information, which is wrong. They must specify what of these. I'll give you one example which I had determined when I was a commissioner. The Western Ghats ecology is under threat. Western Ghats stretch from Maharashtra go down right up to Kerala. At that time, the government had decided that a study should be done so that the ecology would not be damaged beyond repair. Dr. Madhav Gadgil, one of India's foremost environmental experts, was requested to form a committee and investigate and come up with a report. With a lot of effort, in which Dr. Madhav Gadgil and the whole team spent a lot of effort, they came up with a report that showed that certain areas were ecologically very sensitive and that mining should stop, no road should be constructed, and various development, so-called development, should not happen. The government then found it inconvenient, therefore they put it under the cupboard and forgot all about it. Somebody asked for a copy of this report. The PIO said forbidden under 81A, did not specify what. During the hearing, I said, look, you got to say which of these applies. He said, no, sir, 81A. So I said, I'm now spelling out for you. Would it prejudicially affect the sovereignty and integrity of India? Disclosure? He said, no, sir. I said, the security of India? He said, no, sir. Strategic interests of India? No, sir. Scientific interest of India? No, sir. economic interest of the state. Now he was in a difficulty. If he said no to this, he could never have claimed that relations with foreign state or lead to incitement of an offense. He said economic interest of the state would be hurt. I asked him to justify. He was not able to justify. He said development nahi hoga, etc. In a long judgment, I had said that this is wrong. This report must be released. People may protest and say that you are damaging ecology. But if you damage ecology, it will never come back. You damage environment, it is something gone. And you are actually taking away from the interests and the what belongs to the next generations, you are drawing away. If, let's say, something very valuable is there, it can happen even after 50 years. It will still stay there. But if you damage ecology and environment, it will disappear. The reason I'm telling you this is there are many other cases of this nature. The Reserve Bank of India also claimed that economic interests of the state would be affected, which is wrong again. But even if somebody says A to an A, argue and say which interests would be hurt. Otherwise, this is misuse of the provision of the law. Information which has been forbidden to be published by any court of law or tribunal, the disclosure of which may constitute contempt of court. Very often, information is denied on the basis that matter is sub judice. Parliament knew the word sub judice but has not used it. Therefore, to claim exemption under 8(1)(b), a person must clearly specify an order must be provided which says that this information shall not be disclosed of a particular matter, particularly if or things are held in camera, etc. Otherwise, without such an order, 8(1)(b) cannot be invoked, and this is wrong. This is illegal. C. Information the disclosure of which would cause a breach of privilege of Parliament or the state legislature. This is often used. Legitimate usage would be where something has to be presented, let's say budget papers. It cannot be given to you. Inquiry commission reports. The Adarsh Ghotala, a lot of you are aware of. Because of this other scandal, the government at that time asked for a commission of inquiry to be set up. According to the Inquiry Commissions Act, the report should be submitted within 6 months, but in India, a lot of commissions don't do it. They take endless time. The Adarsh Commission took 2 years to submit its report. This report mentioned that certain ministers and senior bureaucrats had been involved in a scandal and that things were not okay. The government did not want to share this, therefore the government put it away. After 6 months, after 7 months of putting it away, after the submission of the report, I asked for the Adarsh Commission report. And the PIO said 8(1)(c), this has not been placed on the House statement of the legislature, therefore it cannot be given. Within 6 months of getting an Inquiry Commission report, the government must place it on the floor of the state legislature. I argued that until 6 months you could claim privilege. Until 6 months it was a privilege of the commission of the legislature to get this report. Once 6 months have crossed, you have already breached the privilege of this state legislature and therefore you will have to give it to me. PIO refused, First Appellate Authority refused. I put the appeal in the second appeal before the commission. And the government realized it had an untenable stand. Therefore, it put it in the state legislature and gave me the report. Inquiry Commission reports cannot be hidden away from citizens any longer. There are times when you have a very peculiar situation, like one I had shared where I was unable to take a decision. Somebody had asked Rajya Sabha Secretariat for details of questions asked in the Rajya Sabha and the notings of that, etc. And the Rajya Sabha Secretariat claimed privilege saying 8(1)(c). Now this was a difficult one. Parliament also has certain privileges and they said that this is part of parliamentary privilege to decide which questions to ask, and the notings of that cannot be provided to citizens. At the end, the solution I found was I did not give a decision on this, but said that I would request the chairman of the Rajya Sabha to determine whether this release should be done or not and whether it would breach parliamentary privilege. There are times when you have to give it to other authorities because there is a conflict of interest. Information including commercial confidence, the disclosure of which would harm the competitive position of a third party, unless the competent authority is satisfied that larger public interest warrants the disclosure of such information. Claiming exemption on the ground that it is commercial confidence. I've had instances where people say there is an agreement with a private party not to reveal this information, this agreement. Therefore, it's confidential. Such an agreement is illegal. The RTI Act prohibits such a thing by implication. It doesn't say so clearly, but there is no such thing like confidential information shall not be given or agreement type as confidential shall not be parted with. Another matter was there where reports of defaults in execution of contracts was there. Somebody had said, I want default. They had asked the third party had said, no, it'll hurt our commercial interest. Yes, it would hurt the commercial interest, but this cannot be considered as hurting their competitive position, or this cannot be considered as commercial confidence. There is a public interest in knowing which contractor has failed in which execution of contracts, and this cannot be denied. Then there is another one, E, 81E, information available to a person in his fiduciary relationship. We'll leave the public interest out of this. What is a fiduciary relationship? In simple language, people believe it is a matter of trust. I would submit 99% of the information in public government records is not held in a fiduciary relationship. What are traditional fiduciary relationships? Banker, customer, lawyer, client, trustee, and beneficiaries, etc. What are the characteristics of this? Somebody gives information to somebody with fiduciary relationship for his or her benefit. B, there is no legal requirement to give the information. It's a matter of choice. And you have a choice of whom to give it, and whether to give it or not is all a matter of choice. 99% of the information that is given to government is done because there is a regulatory requirement or a legal requirement to give that. When you apply for a job in a government, it's not that you trust government or you trust anybody. It is because that's the requirement you have to give. Passport applications, job applications, lot of such applications were denied by PIOs saying people have trust in the government, hence this information is provided. Wrong. This has nothing to do with trust. Yes, in a fiduciary relationship, trust is an element. You trust a lawyer or a doctor, only then will you go to him. But just trust, it's not adequate. And most information is provided to the government not because you trust government, but because there is a regulatory requirement. Reserve Bank of India in 10 matters had claimed fiduciary relationship. We had some citizens that sought for audit reports, NPA details, inspection reports of banks, and so on. RBI had claimed exemption under Section 81A, claiming that India's economic interest would be hurt and the economy would collapse. And secondly, they claimed that this was given in fiduciary relationship. In fairly detailed orders, I had said this is not a fiduciary relationship. And this has been upheld by the Supreme Court of India. It's unfortunate RBI is refusing to honor the order of the Supreme Court also, and it keeps on challenging it, and even today the challenges continue. But the Supreme Court accepted what I said on fiduciary relationship, and in fact used the word in its judgment saying that PIOs terrorize the public by using the word fiduciary. Another interesting case I'd like to share with you, which was slightly complex and difficult one to decide. Psychiatric information is definitely held in fiduciary relationship by the doctor. Now, this was a case where a lady had been put inside an asylum for some months, perhaps, or some days. In her version, this was done by her husband to prove her insane, whereas she was perfectly normal. She had asked for information about the medical reports of the doctors and all treatments done to her. She wanted to establish in a court of law that her husband had wrongly put her in the institution. The hospital claimed that this was information held in fiduciary relationship. And they said it was held by because the information had been supplied by the husband. So they had a fiduciary relationship with the husband. After a lot of determination, I came to the conclusion that this fiduciary relationship with the lady, yes, the lady had provided information, it could not be released. But the lady had a right to get this information. This was one of the very tough decisions that I had to take. Information which would impede the process of investigation or apprehension or prosecution of offenders. Note carefully, in most cases where information is sought about investigations, people use this saying, investigation chal raha hai, iske liye we will not give it, which is wrong. This is information that must be shared unless it can be shown that it would impede the process of investigation. Most of the times, people who have filed a complaint are asking for progress of investigation. This is refused, saying this would impede the process of investigation, saying the investigation is going on. Same thing bureaucrats say, when the process is going on, we cannot share file notings, etc. All of this, realize the philosophy behind RTI. You are the owners of this information. Democracy is rule of the people, for the people, by the people. Therefore, it cannot be denied to you unless there is a specific denial put in the RTI Act. Section 81I. Cabinet papers, including records of deliberations of the councils of ministers, secretaries, and other officers, provided that the decisions of councils of ministers, the reasons thereof, and the material on the basis of which the decisions were taken, shall be made public after the decision has been taken and the matter is complete or over. Provided for, okay. After decisions are taken, also cabinet note and cabinet papers are refused to people. What is the thinking of this? One specific case I'd like to share with you: the National Nuclear Safety Regulatory Act was put up in Parliament by the earlier government, the UPA government at that time. Somebody had asked for a copy of the cabinet note and the deliberations and the file notings in the matter. This was refused. The matter came before me and I argued in my decision that when the matter is complete or over, the law categorically states the government has to share information. We have to put it into public domain. The purpose of the deliberations of the Council of Ministers and others was to decide whether to submit such a bill to Parliament. Once it is given to Parliament, it is a property of Parliament and they can accept it or reject it, or modify it or amend it. Therefore, the matter was complete and over and the information would have to be given. In fact, in this section, Parliament made a very conscious choice, saying citizens must know of the reasons behind bills and matters that are decided by cabinet. And they must be able to discuss the pros and cons of this. The whole concept of democracy is that citizens are the rulers. Our MPs, MLAs, etc. are our representatives. We legitimize them. But the bill should normally be debated and discussed even by citizens and media. And therefore, I had specified in that within 7 days of presenting a bill, the deliberations of the ministers and the file notings, etc., should be put into public domain. For a few months, government followed that, and then of course they stopped following this. But this is something which we must insist. That is a true democracy. If this had been done, a lot of bills may not have had to, a lot of acts like the farmers' agitation, etc., may not have occurred if citizens had been explained the reasons for this. Maybe some changes would have to be made, but that would be the right way or in democracy. The most popular exemption in RTI is Section 81J. Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, unless the information will leave the public interest override, provided that the information which cannot be denied to Parliament or state legislature shall not be denied to any person. 81J is a favorite of public information officers, and maximum misuse of the law is done by claiming 81J. By saying it's personal information, hence it will not be disclosed. What is personal? Anything relating to a normal person, to an actual person, is personal. If we look at this carefully, information could be denied if A, it was personal information. If it was information related to an institution or corporation, it is not personal information. It is corporate information or institutional information. We do not use the word personal. Also, later on, the word of an individual is used. Or it is unwarranted invasion of disclosure has no relationship to public activity or interest. 99% of the information in public records, which is held by government, is the consequence of public activity. What I eat at home doesn't go on to government records. But if I eat in a hotel and the government is paying the bill, then it is part of government activity, public activity, because government has spent money on it. Citizens of India have spent money on it. Or it is unwarranted invasion of the privacy of the individual. The Puttaswamy judgment has complicated matters because they have said privacy is a fundamental right and they have not defined what is privacy. Provided that the information which cannot be denied to the Parliament or state legislature shall not be denied to any person. In fact, when framing the law, Parliament was conscious of the fact that for an ordinary PIO, it may be difficult to decide what is a public activity or what is the privacy of an individual. Therefore, they provided this as an acid test. Provided that the information which cannot be denied to the Parliament or the state legislature shall not be denied to any person. What constitutes privacy? Undefined, difficult to define. My submission is the only permissible restrictions on 19(1)(a) are right to information is a fundamental right under Article 19(1)(a), in which is given by freedom of free speech and freedom to publish. And restrictions on that can be only what are provided for in the Constitution, which provides Article 19(2), which permits reasonable restrictions in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offence. I can spot only two words which can be related to privacy, which is decency or morality. If disclosing some information would violate decency or morality, it should not be given. And it should not be given to Parliament also. And that is the reason this acid test was provided to only 81J. There was a certain argument of civil society at that time that this should be put for all exemptions. What can be denied to Parliament must be denied to citizens, or can be given to Parliament should be given to citizens. But this was ultimately put down only for 81J. Therefore, a PIO must say, I would not give this information to Parliament, and if it violates decency or morality, it should not be given to Parliament and therefore not given to the citizen also. 35%, according to CHRI report, is information which is denied based on 81J. Now, R. Rajgopal is a Supreme Court judgment which was earlier than the RTI Act, but that ratio decisionality remains. And what did it say? It has referred to this. A citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, and education, among other matters. None can publish anything concerning the above matters without his consent, whether truthful or otherwise, and whether laudatory or critical. Once a matter becomes a matter of public record, the right to privacy no longer subsists, and it becomes a legitimate subject for comment by press and media, among others. We are, however, of the opinion that in the interest of decency, Article 19.2, an exception must be carved out to this rule, which is a female who is the victim of sexual assault, kidnap, abduction, or a like offense, should not further be subjected to the indignity of her name and incident being publicized in press or media, which is violating decency and morality. Perfectly correct. This was a decision that holds, even today it holds. In the case of public officials, it is obvious right to privacy, or for that matter, the remedy of action for damages is simply not available with respect to their acts and conduct relevant to the discharge of their official duties. So this categorically stated that matters of public record cannot be treated as private, and this is reflected in Section 81J of the RTI Act. Unfortunately, gross misuse has been done to this. Incidentally, I would like to point out to you that it is part of a fundamental right. This includes right to speech, to publish, to vote, and information as per Supreme Court judgments. The only permissible restrictions are given in Article 19.2, which permit reasonable restrictions. 10 exemptions in Section 8 are to protect harm to certain interests and must be in consonance with Article 19.2. The only two words applying to privacy are decency or morality. Misuse. Section 81J of the RTI Act is being misused by illegal amendment. People are reading it like this. Lot of PIOs, lot of commissioners, lot of judges also. Information which relates to personal information, unless the PIO satisfies the larger public interest, the rest of it is being struck off illegally. So if it's personal information, quite often PIOs refuse information saying it's personal information, and unless you can establish a larger public interest, you will not give the information. Provided that the information which cannot be denied to Parliament or state legislature shall not be denied to any person is also cancelled. We talk of an amendment to the law made by the current government 2 years back, when they amended the provision relating to the salaries and conditions of work of the Information Commissioner. This is a much bigger amendment illegally made to the law, and this is being done by referring to a Girish Deshpande judgment, which was done in the case of an SLP. Mr. Girish Deshpande had sought information about a public servant. The apex court held that copies of all memos, show cause notices, and orders of censure, punishment, assets, income tax returns, details of gifts received, etc. by a public servant are personal information is defined in Clause J of Section 8.1 of the RTI Act and hence exempted and cannot be furnished under the RTI Act. No reasoning has been given. Absolutely not. The performance of an employee officer in an organization is primarily a matter between the employee and the employer. Normally, these aspects are governed by the service rules which fall under the expression personal information. It's unfortunate the Supreme Court did not recognize that the employer is the people of India. It is not anybody else. And this is contradictory to the Rajgopal judgment. The details disclosed by a person in his income tax returns are personal information which stand exempted without any connection. Without looking at the law, without analyzing the law, this judgment was given. However, it was given in SLP. Unfortunately, this is now being treated as the law. It is in contradiction to the R. Rajgopal judgment, and hence it cannot become the law. It does not follow the ratio decisionality of R. Rajgopal and ADR PUCL. In ADR PUCL, the Supreme Court judgment had said that citizens have a right to know about those who want to become public servants. And therefore, we have the requirement of everyone who stands for an election declaring his assets and criminal charges against him. The Girish Deshpande judgment says citizens do not have a right to know about the assets of those who are public servants. This is completely wrong. This is completely wrong and does not do justice to the R. Rajgopal judgment. And this is by coordinate bench. Therefore, in my submission, the R. Rajgopal judgment holds. And I'm explaining this to all of you because I'm expecting that citizens everywhere will start dealing with such rejections, illegal misuse of rejections, and start arguing before various people. It does not deal with the proviso 281J. It completely leaves the proviso out. Denial must state that it is personal information which is not part of public record or is a part of public record, is not unwarranted invasion of the privacy of the individual, and he would not give this information to Parliament. Unfortunately, the Girish Deshpande judgment has been treated as a precedent in R.K. Jain, Subhash Chandra Agrawal, and Canara Bank. Many PIOs, government departments, and commissioners quote this. This must be opposed. Most information relates to some person. Whenever PIO does not wish to give information, Section 81J is claimed. This is becoming rampant. It's spreading across like a cancer, and this is an illegal amendment to the RTI Act and constraint on my fundamental right under Article 19(1)(a). And I'm hoping citizens will, whenever they file an RTI application, it is rejected on 81J, will argue with the First Appellate Authority and the Commissioner. 41B of the RTI Act requires this information to be displayed suo motu. Monthly remuneration received by each of its officers and employees, manner of execution of subsidy programs including amounts allocated and the details of beneficiaries of such programs, particulars of recipients of concessions, permits, or authorizations granted by it. All of this, according to the Girish Deshpande judgment, is wrong. This is a very major amendment to an act which promises fundamental rights of citizens and must be opposed. By opposed, do I say we should downgrade the Supreme Court or any court? No. All courts must be treated with respect. But it should be argued that Girish Deshpande is not relevant to other judgments to the privacy issue and should be treated only for Girish Deshpande. Various things that have been refused, I am putting here. You can get a copy of this presentation from Moneylife Foundation. These are all unfortunate things that are, and this is expanding. Anything relating to person, if we continue like this, only budgets would be given. Anything with the name of a person would be denied because it's personal information. Section 11 is not a exemption at all, but it's being treated as an exemption, where a PIO intends to disclose any information or record or part thereof on a request made under this act which relates to or has been supplied by a third party and has been treated as confidential by that third party. The PIO shall within 5 days from the receipt of the request give a written notice to such third party on the request and of the fact that the public information officer intends to disclose the information. When can a PIO intend to disclose information? When he feels it is not exempt and the information exists. And invite the third party to make a submission in writing or orally regarding whether the information should be disclosed, and such submission of the third party shall be kept in view while taking a decision about disclosure of information. Very often, people say this third party information, therefore it will not be given. Wrong. That is not the law. The law requires that the third party be given an opportunity to take an objection. Some people say, then why is Section 11 there? It is because some information which may harm a third party, as per Section 8(1), the PIO may not appreciate. He may not realize that this is likely to damage the third party's interests, commercial interests, or other interests which are safeguarded. And therefore the view, but even if the third party objects, it does not. Section 11 is not a veto given to third party. While taking a decision about disclosure of information, third parties' objections shall be kept in view. The PIO must come to a conclusion independently that this is exempt. Otherwise, he must tell the third party, I'm giving the information, it's not exempt. Third party also can go into appeals. What do we need to do? In appeals, argue that the exemption does not apply. In case appellate authority does not agree, it says that you should refute your points of law and put it in order. Argue based on the legal grounds saying that this is not exempt as per the law. In most cases, avoid trying to justify disclosure in larger public interest. It works very rarely. It's a very difficult determination to make for a commissioner when he is told that an exemption applies which should protect certain interests. And then there's a larger public interest in disclosure. In very rare cases will this argument work, and I have seen a lot of RTI applicants arguing only on larger public interest, therefore they almost concede the game away, saying that it is exempt. You must contest an exemption. Don't try and go on larger public interest. This is a very difficult decision to make. In fact, I cannot, out of over 20,000 decisions that I gave, I'm not able to recall. There may be one or two, but I'm not able to recall instantly where I have considered that an exemption applies and there is a larger public interest. I may have written that there is a larger public interest also, but only if it is not exempt. If it was exempt, I don't recall any decision, and try and see if you can locate any decision by any commissioner saying that it is exempt and the disclosure should be made in larger public interest. It's very rare. There is a demand for RTI applications, the responses to be put on websites with word search facilities. This should be searchable by PIO name, applicant name, department, and subject. Getting a portal like Jan Sutna portal of Rajasthan, beautiful portal has been made by Rajasthan, and all dashboards seen by officials should be open for viewing to citizens. NCGM, for example, has a SAP program. They have a lot of dashboards which can only be viewed by the officers. These should be open for viewing to citizens. That would give us a lot of information, and the RT applications can be lower. Monitor the work of the Information Commission. Persuade one or two law colleges or bar associations to take up ownership of this. Try and get the Information Commission to dispose cases in a time-bound manner. Today, one of our weaknesses is that Information Commissions are taking 1 to 2 years to determine cases. This needs to change. There's a PIL we put in the Bombay High Court because there are 3 High Court decisions of Karnataka and Calcutta High Court saying that Information Commission must dispose of cases in 45 days' time. There is no time-bound disposal, and this would make RTI, instead of right to information, become right to history, which is not acceptable. Hold meetings regularly to discuss RTI issues. There are a few such groups that have come up. This should spread. In case of attack suspected to be because of using RTI, Information Commission must order disclosure of all the information sought by the victim on the websites of the departments. Use section 81F to ask for specific information on website. If you feel certain information in a certain format would be very useful, file a complaint to the Commission under 81F and give a format and say that please order this. I had issued over 100 orders. Chief Information Commissioner of Maharashtra, Ratnakar Gaikwad, has also issued many such orders, partly as a consequence of my application and also of other appeals. Keep raising the demand for 11 information commissioners in Maharashtra. Otherwise, Maharashtra is sunk. There are over 100,000 appeals and complaints pending in the Maharashtra Commission. Try and get this as a commitment from political parties with the promise to ensure no positions left vacant. Raise the demand that information commissioners must dispose at least 6,500 cases in a year, giving the option of video conferencing to appellants and officials. There is no need. We are all now on a Zoom call. There are other platforms also, and the commissioners must give the option of video conferencing to appellants and officials, in which case applicants can sit in their own office or home, and government officers can also sit in their office or home, and these decisions can be given. Insist that before the shortlist for selecting information commissioners is sent to the same committee, one interview should be open to public. That would ensure that people would know about RTI, and that would give us some commitments from prospective people who want to become commissioners. RTI activists should also apply for information commissioners positions. I submit it is very important whether they select us or not. Sometimes some good RTI activists could get selected. A small tips I want to leave you with: keep RTI applications focused and short. Quite often people land up with very long stories. You don't need to justify why you want RTI application. Don't need to give your details of your grievance. Keep it focused. It gets you better results. Carefully draft your application, understanding that RTI will only obtain what is on record. Think of what the record may have, and if there is no record, put a sentence there saying if there is no record, this should be stated, which means something that you believe should be on record has not been done. No investigation has been done, for example. That should come to you as an RTI response. Do not tend to taunt or use sarcasm to unburden your dissatisfaction in government working. I've seen this flaw in a lot of appeals. They use sarcasm. It upsets the opposite person. Even if he's a good public information officer, it upsets him. When you receive the PIO's response, read it carefully. If you have difficulty in understanding the language, take help. I've had people who cannot understand Marathi reading something in Marathi and saying the complete opposite of what the order says. If the response is not adequate, draft your appeal carefully, giving a brief argument in the ground for the appeal. Give the same respect to officials as you would like them to show to you. Insulting another human being is ethically and morally wrong. You debase yourself. Please don't do it. We have a good tool. Let us use it. Now I'm done with my presentation and we can open up for
Yes, sir.
questions and
Thank
answers.
Yeah.
Feel free
If
to
any,
dispute what I say. Do not hesitate. My having been a former information commissioner doesn't make a difference. Today I'm not an information commissioner. Even if I was, dispute, disagree with things, let's discuss. Thank you.
if anyone has a question, they can use the raise hand button to ask that or post it in the chat. There's a question from Namit Kothari in the chat. He's asking, how can whistleblowers save their lives from potential life threats?
See, ultimately, there is no hard and fast safety that can be made available. But that was one of the suggestions I gave, that whenever somebody is assaulted or killed, all information sought by him should be put into public domain. If this is done, it is expected that people would be careful about not hurting RTI applicants, because that would ensure that all the information would go into public domain instantly. Commissioners must do this. I had got the Central Information Commission to agree to this. You should get all state commissions also to agree to this. That would be your best way of protecting the whistleblowers. Otherwise, Whistleblowers Act or anything is not going to work. I don't see it working. Another tip: when you are doing a whistleblowing act, getting information in RTI that looks damaging, share it publicly. Share it with Moneylife, share it with other media. That is your best defense against an attack.
There's another question regarding section 81D. He's put out an example. He's saying, let us say there's a contract for operating systems of computers for a school, and the vendor sets up a proprietary operating system like Windows. In view of the cyber attacks from overseas, can the source code of the operating system made be public? I don't think they can
No,
be, because it's, yeah.
This is a topic on which I do not think I have adequate knowledge to be able to.
It will probably be blocked under copyright law, and you won't be able to share the
Right.
source code.
So I said this is subject that I don't know, but since you know, your guess is better.
There's another question from Sachin. He's saying, can you provide us a template on how to respond to stonewalling by coding section 81J? Is there any template?
If somebody sent me an email, I could send them not a template, but an argument that can be placed against 8.1J, most of which I have said in words, use the same arguments to appeal against the rejection by 8.1J.
Is there anyone who would like to ask a question? They can use the raise hand button.
Mitu has asked one question about if the judgment or order of CIC is not accepted by the applicant, then what is the option for the applicant?
The only option is to go in a writ petition to the High Court.
Is there anyone else?
No, I don't think there's anyone else in the chat. If anyone wants to ask a question, they can use the raise hand button and we'll unmute you.
Okay, we'll just take the last question then in that case.
I don't think we have any more questions. Okay, I think we'll end the session here, sir.
Right.
Thank you so much for giving the presentation today, sir. I hope everyone found it useful. We will join again in a fortnight for another session. It will be on a different topic, and we'll have other RTI activists sharing their success stories. And I think ma'am has joined. Sorry, but we were just ending. Mr. Gandhi, if you'd like to share anything while closing.
Including remarks.
No, on 8.1J, I think I concede that there is a controversy, but I believe that there is a great need of people discussing this. And when I talk of misuse of exemptions, again, I expect that there should be great public discussion. Don't accept anything that I say. Look at the language, look at the law, and decide whether transparency is better for the nation or less transparency would be better. I have a great belief that democracy is good for the nation, and democracy involves respecting the individual citizen as the sovereign of this nation. And I am thankful to Moneylife and to all of you for participating in this.
Thank you, sir.
Thank you so much, sir.
Thank you.